Welcome to SCOTUSCast, a project of the Federalist Society for Law and Public Policy Studies. Our contributors join us from around the country to bring you expert commentary on U.S. Supreme Court cases as they are argued and decisions are issued. The Federalist Society takes no position on particular legal or public policy issues. All expressions of opinion are those of the speaker.
Thank you for tuning in for the October 21 term of SCOTUScast. I'm your host, Nick Garfinkel, on behalf of the Faculty Division of the Federalist Society. On December 10, 2021, the U.S. Supreme Court decided Whole Woman's Health v. Jackson and dismissed the federal government's suit against Texas and United States v. Texas. The court held 8-1 in Jackson that plaintiff abortion providers can pursue claims against licensing officials. Justice Gorsuch wrote the majority opinion, joined in full by Justices Alito, Barrett, and Kavanaugh, with Justice Thomas joining as to all but one part. Chief Justice Roberts wrote an opinion concurring in judgment in part and dissenting in part, in which Justices Breyer, Kagan, and Sotomayor joined, while Justice Sotomayor wrote a separate opinion concurring in judgment in part and dissenting in part, in which Justices Breyer, Kagan, and Sotomayor joined. A pair of distinguished federal court scholars join us to discuss the cases, the legal issues involved, and the implications going forward. Listeners may remember they joined us for the post-argument episode. They are Professor Stephen Sachs, the Antonin Scalia Professor of Law at Harvard Law School, and Professor Howard Wasserman, Professor of Law at Florida International University College of Law.
Thank you, Nick. Thank you for having me, and thanks to everybody for joining today. So a very quick background on SB 8 and sort of the lead up to the two decisions that the court issued on Friday. So SB 8 is called the Fetal Heartbeat Act, and the main substantive provision is a ban on the performance of abortions after detection of a fetal heartbeat, which usually occurs about 5 or 6 weeks of pregnancy. It requires doctors to check for a fetal heartbeat and prohibits the abortion if one is detected, subject to certain exceptions with respect to the life or health of the pregnant person. The law is invalid under Roe and Casey, which established the proposition that a state cannot prohibit pre-viability abortions in this way. What was different about SB 8, though, was it didn't provide for any sort of public enforcement, such as by the Attorney General or by the head of the Department of Health Services. And instead, it created a private cause of action for any person, regardless of injury, regardless of any connection to the particular abortion, could sue either the doctor or clinic that performed the abortion, as well as anybody who aided and abetted that abortion. In state court, and could recover statutory damages of a minimum of $10,000 per unlawful abortion, an injunction prohibited future unlawful abortions, and attorney's fees. And the idea behind the law was basically to either sue abortion providers and advocates into stopping their activity or chill the activity with a threat of lawsuit and crippling liability. Now, the abortion rights community followed its usual course, which was to file a pre-enforcement lawsuit before the law actually took effect, seeking a declaratory judgment of its invalidity and an injunction prohibiting its enforcement. And they sued the usual suspects like the Attorney General and the head of the Department of Health Services. They also sued the heads of various medical licensing boards afterwards. They then sued a state judge as a potential class representative, a state clerk of court as a potential class representative, and Mark Dixon, who is the head of the East Texas Right to Life. And the defendant's arguments in this lawsuit was, you can't sue us because there is no public enforcement. Then there's no one for the federal court to enjoin. There's no standing. There's no waiver of sovereign immunity because you don't have a proper defendant who is charged with enforcing the law. When that lawsuit ran into some not unexpected hurdles, the United States filed a lawsuit against the state of Texas, seeking a global injunction against anyone connected to the state of Texas enforcing the law. The United States actually succeeded in getting a preliminary injunction. SCOTUS then granted cert before judgment in both cases with an expedited briefing schedule of about 5 or 6 days, and heard oral arguments on November 1st and announced the opinions in both cases last Friday.
Thank you. I'll take over and discuss the opinions themselves. So it's somewhat of a fractured decision. In the U.S. versus Texas case, it's very simple to summarize. The court just dismissed it as improvidently granted. But in the Home Women's Health case, the court, per Justice Gorsuch, allowed a very narrow means for the provider suits to go forward against some of the defendants, but in such a way that signals that they really won't get what they want from the courts below, which is protection in general against the future private suits. So Justice Gorsuch, writing mostly for 5, except for one part of the opinion that I'll raise later, held that that many of the defendants were not proper defendants under Ex parte Young and could not be sued by the providers. So, for instance, the state court judges, Ex parte Young had said that the machinery of the courts could not be the target of an injunction, or that would disrupt our whole scheme of government. Likewise, the state court clerks, who are merely part of that machinery and whose only job is to file the suits that are brought to them. They're for one thing, outside the explicit terms of Ex parte Young, but they're also not adverse to the providers who are suing. The clerks are not on the other side of the lawsuit. They're merely the people handling the lawsuit, and the people who are on the other side are the private plaintiffs. The problem is, of course, you don't know who they are, and so you can't sue them yet, by and large. But the court said that they are not. The clerks and judges are not sufficiently adverse. There is no case or controversy under Article 3 between the plaintiff providers and those judges and clerks. It also noted some practical problems that might ensue if judges or clerks were allowed as defendants. They have been made defendants in some prior cases where in some sense they were going off on their own to impose a rule, generally not when they're merely filing or processing the claims brought by others. In general, it's not the clerk's job to read the complaint or to know what it says. It's their job to stamp it and make sure that it's filed. And the kinds of review that would be necessary to figure out whether a new claim is brought under a statute that qualifies for the extraordinary treatment that the parties were seeking for SB 8, the majority was very skeptical that that could be done, and indeed suggested that the other dissenting opinions had not fully worked out what that regime should look like. Likewise, the majority held that there could be no suit against the Texas AG because they lacked enforcement authority as relevant here, and that even if a suit were brought against them, a judgment against them couldn't bind all of the private plaintiffs who might try and sue under the Texas statute, and so wouldn't really get the providers what they want. There was one category where the court said that a suit could go forward, and that was as to the licensing officials. So here the argument really was that the architects of the statute didn't quite dot their I's and cross their T's well enough. and that the statute still permitted some public enforcement by the health and by the Texas licensing officials, whose job it was to deny licenses and otherwise initiate enforcement actions against doctors who violated the health and safety code, of which this new SB 8 is part. There is broad language saying, notwithstanding any other law, that there's not to be public enforcement here in SB 8, but the court said that that was limited by other portions of SB 8 that said not to read it to limit the regulation of abortion under other statutes, and combining the statutory provisions in the view of the majority of the court, the licensors had authority to enforce the statute and therefore could be sued in a standard ex parte Young way. That part of the decision was actually 8-1. It was the rest of the court against Justice Thomas who dissented on that ground in particular, and held both as a matter of Texas law, the Texas statutory interpretation that the licensors could not enforce on their own, but also as a matter of ex parte Young factors, that there was not the immediate danger of enforcement that was necessary to sustain a suit under ex parte Young on those grounds. And no one seemed to think that the private party who was brought along for the ride could be sued here or had any intention to sue anyone. So what this means from the majority's judgment, combining, the parts that had 5 votes and the parts that had 8 votes and so on, is essentially that some suit can go forward against the Texas licensing officials unless the district court and the Fifth Circuit take a narrower view of Texas law or more information comes out about Texas law in the interim. I mean, what the court is doing here essentially is an eerie guess about what the content of Texas law is. And even if the providers win a judgment on that, all they get really is a district court judgment. And the real ball game will be how quickly will they get a merits ruling in the Fifth Circuit, and will it come down before any decision in Dobbs, which I'm sure that Professor Wasserman will discuss later. But what they did not get was a remedy that would enable them to bar a new suit by a private plaintiff tomorrow. So if a provider performed an abortion tomorrow and were then sued by a private plaintiff, nothing coming out of this lawsuit would hold that private plaintiff in contempt for filing the lawsuit or would anyway bar the lawsuit. There would just be the question under existing precedents, can that lawsuit go forward, but it would have to be litigated in that fashion. I want to briefly, before going back to Professor Wasserman, mention the dissents, both by the Chief Justice and by Justice Sotomayor. The Chief Justice's dissent for 4 votes said that a suit against the Texas Attorney General would be okay under Ex parte Young, in part reading the Texas statute slightly differently so as to allow for slightly more enforcement authority vis-a-vis the Attorney General. More significantly, the Chief Justice would have allowed suits versus the court clerks. This is more significant because that's really the remedy that one of these plaintiffs needs in order to bar a future suit against them. And the chief differentiated clerks from judges, saying that no suit could go forward against the judges, but that a suit could go forward against the clerks because they play a distinct role. They set the litigation in motion. And he noted cases in which the court had enjoined, or federal courts had enjoined state court proceedings. There's a very brief discussion and not a lot of detail of the kind that the majority of the court was seeking, and how exactly would a remedy against the clerks work? How would it be consistent with due process for the parties who had not yet brought suit? How far would it extend to other folks with ministerial obligations vis-a-vis lawsuits? And when is it that a clerk of court is performing, in some sense, an unlawful act just by docketing a lawsuit that is brought under an allegedly unconstitutional statute? These questions were still open under the Chief Justice's opinion, who instead emphasized that the purpose and effect of the statute was to nullify the court's rulings and, in his view, to limit the role of the Supreme Court in our constitutional system. Similarly, Justice Sotomayor, writing for only 3 justices, not including the chief, emphasized the chilling effect that the statute would have. And in addition to arguing that the clerks and others were proper defendants, argued essentially that the district court can handle all the implementation questions. We don't need to figure out exactly what an injunction against the clerks will look like. They can figure that out. Maybe even the private plaintiffs could be enjoined directly because they're being deputized by the states here. But really, it emphasized the idea that Texas was in some sense at war with the court's rulings. And I use that term advisedly in the sense that she cited the address of John Calhoun, claiming that the state was seeking to nullify federal law, cited disapprovingly, very much so, the architect of the statute, Jonathan Mitchell's brief, which stated that the Supreme Court's interpretations of the Constitution are not the Constitution itself. They are, after all, called opinions, and stated that the nation fought a civil war over that proposition, but Calhoun's theories were not extinguished. Others before have noted that this is slightly incongruous, since to the extent that the Civil War was about the authority of the Supreme Court, the other side won, in that it was Lincoln who challenged the authority of the court in Dred Scott and Douglas who upheld it. Of course, what Justice Sotomayor was really getting at was the relationship between state and federal government. To what extent will the federal government and the federal courts settle a question in ways that state laws cannot inhibit? One thing I do want to note, though, before handing it over to Professor Wasserman, is that in his article, sort of laying out the ideas behind the statute, Jonathan Mitchell had noted that the real issue here is not the relationship between states and the federal government, but rather between courts and their successors. So the real question here is not whether the issue will come up in court, because it definitely will. I mean, it's coming up in a large number of state courts. Indeed, as the majority noted, there's a great deal of litigation in Texas right now in this question. A recent opinion by a Texas state judge held SB 8 unconstitutional as a matter of the Texas Constitution, arguing that it improperly deputized officials delegating power and exceeded the Texas Constitution's standing requirements. So it's possible that this will be resolved by courts, which are indeed following the precedents laid down by the Supreme Court until the Supreme Court chooses to overrule them. The question is which courts and when. Will it be done post-enforcement? Will it be done in state court? Will it be done in federal court? And who are the proper defendants? The state litigation is all sort of one-on-one in some sense between the parties who are actually suing under the statute or the parties who are threatening to sue under the statute and providers whose conduct might be chilled thereby. Here, the real question in the SB 8 case that the Supreme Court had was whether you could go after a defendant class of state judges or defendant class of state clerks and get a single ruling that would close off all avenues for a suit. That, it seems, is not going to happen unless something interesting goes on in the U.S. versus Texas lawsuit, which is still out there. But it seems that for now, at least, it's the one-on-one state litigation that's going to proceed. Back to Professor Wasserman.
I just wanted to jump off on a couple of points that Professor Sachs made, and then kind of suggest where we go from here. So, one X factor with the lawsuit against the federal lawsuit that might go forward against the licensing boards is whether the state has any incentive to appeal, even if the district court declares the law constitutionally invalid and enjoins, say, the medical board from taking away this doctor's license. The state might just decide, okay, we're not going to bother appealing. And so now you have the district court's very narrow injunction. You have the district court's persuasive precedent, but nothing else. We're not going to give the Fifth Circuit a chance to make a decision. The second thing is that even if you give the Fifth Circuit a chance to make a decision, that doesn't necessarily provide the precedent that you want, because the Texas Supreme Court has decided that Fifth Circuit precedent is not binding on the Texas courts. It's persuasive. It has the same force and effect as a district court judgment. The second thing, and Professor Sachs hinted at it, is for lack of a better term, judicial supremacy or idea of judicial supremacy that underlies the both the Chief's and Justice Sotomayor's dissenting opinions. That, in sort of the Cooper versus Aaron, we get the last word on the meaning of the Constitution, and the state cannot act in any way that runs counter to that. And related to that is the assumption, and this goes back to the Jonathan Mitchell's point, the assumption underlying the dissents is there shouldn't even be litigation about it. That having to litigate constitutional rights is itself a violation of constitutional rights. That having to go through the steps of arguing and getting a new ruling that this new law is constitutionally invalid in light of prior precedent is itself a violation of constitutional rights, and that just never has been the case. That judicial review means that it's the judiciary reviewing, but the judiciary reviews things when it comes up through litigation. So there's this odd disconnect where this law is undermining judicial review by making the courts do something, and it seems a strange position to try to balance. So what happens now? So besides the lawsuit against the licensing boards, which I expect the district court to issue a preliminary injunction unless the state officials can make a really convincing argument that state law does not authorize any use of an SB 8 violation as a predicate act for a licensure action. And then we're back to the question of really narrow injunction. What does the state choose to do? There are 3 pending SB 8 actions in state court, all against a doctor named Alan Braid, who set up a test case in the best tradition of American constitutionalism, where he performed one on lawful abortion and then wrote about it in the Washington Post. And he's been sued by one anti-abortion rights group and 2 very strange private individuals, neither of whom is from Texas. But that's really set up, as this whole thing should be, that's set up for them to then defend, get this action dismissed, and get a state court ruling on it. And then the third thing, as Professor Stack mentioned, is the state court action that ruled that the procedural aspects of SB 8, the delegation of private enforcement authority, the limits on raising affirmative defenses, and one other procedural issue, I'm drawing a blank on which one, but 3 of the procedural aspects of SB 8 are invalid under the Texas Constitution. Now, these are all issues that we would have expected to see doctors or clinics raise in an actual SB 8 action, in addition to the core provision being invalid. Hey, this guy can't bring this lawsuit because, Texas cannot just grant standing in this way to any person. The state trial court said, no, we can do that pre-enforcement in a declaratory judgment action. Although interestingly, it was a declaratory judgment, and the court explicitly declined to issue an injunction. So the next stop for that is going to be, I imagine, the Texas Court of Appeal, the Texas Intermediate Appellate Court. The interesting thing there is, I'm not sure why that lawsuit was brought against an anti-abortion rights organization that there's sort of some open questions about whether they or their members intend to bring lawsuits or not. So I think some of the same traceability problems, some of the same standing problems that apply to Mark Dixon in the federal court may also apply to the organization there. But so that action and those 3 actual enforcement lawsuits are the ones to keep an eye on. I guess and Professor Sachs, you want to talk about what might happen with the United States lawsuit, which is back down to the Fifth Circuit?
Sure. So in some sense, we're not really sure, because the position of the United States was essentially that even though there's no obvious source of a cause of action or authorization to sue in equity for the United States here, it was okay because of the very unusual circumstances of this case where there's no other route to pre-enforcement review. It's not clear what the Fifth Circuit is going to do with that argument. I mean, again, so the district court had issued a preliminary injunction. The Fifth Circuit, Texas immediately appealed. The Fifth Circuit stayed that injunction, and the U.S. sought in the Supreme Court to vacate the stay or else have certiorari before judgment. The Supreme Court granted certiorari and then changed its mind and dismissed it. So now we're back in the Fifth Circuit, and presumably the lesson of this opinion is bad for the United States' suit in two ways. One is that it seems that a lot of the actual outcomes that the U.S. wanted, namely an order forbidding Texas state judges from hearing cases under this law, which is the sort of order the district court had issued before it got stayed, that seems in some sense out as a result of the Supreme Court's opinion. It's not absolutely, definitely out. This is an opinion about ex parte Young and sovereign immunity, which is not an issue for the United States. But some of the discussion of adversity and some of the discussion of sort of who is doing what that's unlawful here, I think is probably going to throw cold water on a lot of the United States' remedial theories. The other problem for the United States' suit is that the whole premise of their suit was that there's no other route. Well, now the Supreme Court has identified a small other route, namely against the licensing boards and the licensing officials. So at least as long as that remedy is still kicking around, you can imagine the Fifth Circuit saying, that's enough. What more do you need? I imagine the providers would say that we need a great deal more than that, and the United States would probably agree. But it will take a while for that issue to get hashed out. And honestly, I would not be surprised if what we see in the Fifth Circuit is a round of briefing. Maybe they'll calendar some oral argument, and in the meantime, Dobbs will be decided, and the issue of whether Roe and Casey are still good law will be determined, and that will have its own effects on this case. So I think that really the U.S. litigation is in sort of a holding pattern until we figure out what else is going on.
Thank you for listening to this episode of SCOTUScast. SCOTUScast is a project of the Federalist Society, a not-for-profit educational organization of conservative and libertarian law students, law professors, and lawyers, founded upon the principles that the state exists to preserve freedom, that the separation of governmental powers is central to our Constitution, and that it is emphatically the province and duty of the judiciary to say what the law is, not what it should be. Don't forget to subscribe to our podcast series, including SCOTUScast and Practice Group podcasts, on iTunes or Google Play. For an archive of past podcasts, as well as audio and video of past Federalist Society events, please visit our website at fedsoc.org/multimedia. That's fedsoc.org/multimedia.
This has been a FedSoc audio production.